Okay, Rennie, you're all set on my end.
Tuesday night, I know we've got a meeting. Yeah. Yeah. Hey, Alyssa? Or is it Andrea?
Hey, Elisa, you're all set on this end? You're live
Okay.
streaming.
Do you know whether Don or Patrick are coming here in person or are they on the call?
Right now, they are not on the call, and I
Okay.
don't know.
All right. Thank you.
Okay. You're welcome.
Yeah, I'm going to mute for just a minute until we get going.
Okay, good evening, everyone. This is the December meeting of the Laws and Rules Committee. We are still waiting on one committee member, but we haven't heard from him, Patrick. So, Michelle, would you be willing to fill in for Patrick? Okay. So.
He often comes late. You tried to text him?
Andrea just texted him.
Okay.
He texted me this afternoon asking whether the meeting was going to be in person or virtual.
Okay.
But he didn't say whether he was going to be here.
Okay.
So the first item on our agenda is the open meeting law amendment. Communication was submitted by Emily Flynn. Would you like to?
Hi, to see you again so soon after.
You know, one second, it's really confusing on there. There's two conversations going on, so we have to wait for that. Okay,
Have you all gotten paperwork, or I printed some out just in case?
Oh, if you have the committee report.
I'm so glad I
Thank
printed it
you.
out. I'm not sure where to start, so why don't I pass out the resolution that I'm proposing? Because that's probably the meat of our conversation.
I read it. I'd like to hear it.
Okay.
I have.
So the tree-
You were just put it in layman's terms?
Sure, I'm happy to. And also, I think on the call is Troy Ellen Dixon. She's the chair of Lidwell Kingston. And she penned the letter that Lidwell Kingston is sending to our state representatives. But let me step back. So, as you all are aware, Lidwell Kingston and the Common Council are all under the open meetings law that says that you have to provide access to the public. So a lot more, I'm not a lawyer, but that's the general gist, right? So, during COVID, Governor Cuomo, I don't know the numbers of the law, but he passed an executive order 202.1 that allowed us to meet remotely. And with the technology that we're using right now, it also allowed us to meet and not have the commissioners publish their location of where they're calling in from and still be able to participate, still be able to vote, still be able to conduct business.
What's a commissioner?
So Lidwell Kingston is the commission. So the commissioners are the ones that the mayor has appointed and are the deciding members.
Okay.
So really the nutshell of it is we are proposing that the state amend the open meetings law to allow us to conduct business as we've been doing since COVID, still allow access because we provide the meetings here at City Hall. Anyone can come here and participate, but my commissioners would be up on the screen and able to conduct business, but not have to put their addresses published on the agendas. That's really the crux of it.
Is that what they have been doing?
So, January 15th, when, let's see, which one is it? Chapter 17, the provision that was extended expires. In order for my commissioners to participate, they will have to publish their address on the agenda. And I think that's true for you all as well. So, in the past, before COVID, I've seen older people call in with a conference phone call, and you have to publish your address in order to participate. So this would affect,
To show that you're a resident
um,
of the city or.
I don't believe that's the language of the law. It's not to show that you're a
It's to
resident.
show the address where you will be attending the meeting so that any member of the public can join you there.
Oh, right.
So if you're sitting on your porch, you're sitting at a Starbucks,
Got it.
you're sitting at a parking lot, the public has to know where you are, even if you're not in person.
Understood.
My understanding, my understanding of the law is allow access
Uh-huh.
and that people can witness the legislation that's happening.
Right, like Kipper just said.
Yeah.
Yeah.
My argument is that as long as the meat of the legislation is happening here, it's much more public accessible here with an elevator, it's ADA accessible. My home is not ADA accessible, for example. So to me, I feel like we fulfill that requirement. As long as it's seriously called.
Why are people against that?
I don't know too many people that are. I just.
No, against publishing their address.
Oh, for safety reasons. So in this day and age, publishing an address can feel very vulnerable,
Right,
especially if you're a public person.
right, you'll be attacked.
No, hopefully not.
Okay.
But I mean, I think that's there's a number of reasons why you might not want to publish your address and still be able to participate
Yeah,
in government.
yep,
Yeah. So, I can also say that, so we're not the only people that are considering this. The other body that we picked up legislation from is the New York State School Boards Association. I picked up some of their language. But we would be one of the first municipalities to do a memorializing resolution.
and why is it coming from your commission?
My commissioners feel very strongly about it. It's also health and wellness. Access to feel safe and be able to participate in government, I think, is a form of wellness.
Okay.
Have you communicated with other commissions? Because I know I agree with you that it can feel very vulnerable. As elected officials, our addresses are public, but I'm leaving office in January. My address will still be public after that. So I can see how that can feel very vulnerable.
Let's see, I did hear from two other commissions. Civil Service the Civil Service Commission expressed interest in supporting this. And what is it? Mandy conducts a commission.
Community development.
Thank you. So both Jackie and Mandy emailed me and expressed interest in this as well.
Well, with this being a memorializing resolution, how is this going to, is it going to have any effect? Is it going to actually change anything?
So I would say that we are asking the decision makers to make the change. So it's a memorializing resolution calling upon Assembly Member Kevin Cahill and Senator Michelle Hinchy, because they're our state representatives and it's a New York state law. So they're the ones that would make the change in the meetings law. So we're asking them to consider amending it going forward, and then we're asking the city clerk to send copies of this to them and tell their elected officials. So no, there's no real change that would happen in city law. It's a memorializing resolution.
No one has sponsored this yet at the state level?
No, I haven't seen it.
Okay.
But I believe Troy Allen has informally talked to Manager Green, but I don't know if it has happened officially.
I was just going to move that we adopt the resolution.
Okay, we have a motion. Is there a second? Second by Don Collerman. All in favor?
Any discussion?
Oh, any discussion? Sorry.
No.
Any other discussion? All in favor? Okay. Thank you, Natalie. Good luck with petitioning. I think this is a good, it's a good move.
Thank you very much.
This is Troy Ellen. I just want to say thank you very much for your support. It's much appreciated.
Thank you for all your work.
Thank you for initiating this. Thank you.
Oh, so the motion that we just voted on reads, a memorializing resolution that supports legislation to amend the open meetings law to provide enhanced opportunities for the conducting of business at a meeting of a public body through the use of remote meeting technology. B, authorize committees of a public body to meet through the use of video conferencing without a fixed location for the meeting. And C, eliminate the requirement that a public body subject to the open meeting law identify the location from which a member of the public body will be attending remotely, and eliminate the requirement that members of the public be accorded the right to attend such meetings at those remote locations. That is going on. The second item on our agenda is a communication that was submitted by Alderman Davis. He called me this afternoon and requested to have this removed from the agenda. He's still doing some outreach on the matter. So that concludes our new business. Now we move on to the old business. We only have one item, and that is the local law 1 of 2022, good cause eviction. Is there, oh, did you?
Oh, she's going to sign for Patrick, okay.
Yeah.
Mine's for itself.
Sorry, Joe.
So is there a motion to enter into discussion? Motion by Rennie Scott Childress. Is there a second? Second by Rita Worthington. Okay, any discussion?
There are a number of recommendations, so the motion is that we accept the resolution as amended. There are two places where there's a choice to be made.
Okay.
And so the first one is under section 4, where the definition of disabled persons, there's two different ways to do that. One is to use the definition set forth in the New York State Public Housing Law. The suggested amendment would be set forth in the New York State Human Rights Law and ADA, which gives a somewhat wider coverage, particularly to people who are recovering from substance abuse, for example. So we would need if we want to give it the wider definition, as I understand it, we would need to accept that change.
So you just make a motion to accept the change?
Yeah, that would be a motion to amend.
Motion to amend the definition of disabled persons.
Okay, do we need to do reports for any of this, or do we do one at the end saying as amended?
As amended, I think it's fine, I think. I'm happy to be.
Is that the case, Barbara? Do we need, if we are doing amendments, do we need committee report for each amendment, or could we do one at the end saying as amended? If
I believe the way that you proceeded in the past makes sense, and that is to do it at the end.
Thank you. Okay, so what was, Rita, were you making a motion to amend the
Yes.
definition?
Yes,
So going with the broader definition?
yes.
I'll
Okay.
second it.
Okay. And so there's a motion and a second to amend the definition of disabled person. All in favor of that amendment?
Aye.
The second one is in section 6, subsection A, number 1, in the middle of that paragraph. We change the phrase relative to the tenant's ability to afford said increase. Rather, it would be relative to the tenant's income.
Okay.
Because income is a much clearer number than trying to judge tenant's ability to afford.
For that amendment? Motion by Michelle Hirsch. Is there a second? Second by Rennie Scott Childress. All in favor?
Aye.
Well, discussion now?
Oh, yeah, okay.
Well, first of all, we're just discussing this other change, right? Are we also going to discuss the the overall.
Yeah.
Okay. Regarding this change, if you're just relating this to tenants' income, I think that's dangerous because if I'm a landlord, housing provider, I will always then be looking for higher income people, and I don't want to exclude lower income people. So for instance, this would make me not want to lease to a musician perhaps, because they may not be a higher, so this is just a trigger point for me to exclude those that do not have a higher income.
So how would you, are you in favor of keeping it?
No, that's not good either.
Okay.
If any of you guys have
That's not what this is doing, though.
go ahead.
At this point, because this is in a clause that's talking about grounds for removal of tenants. And so the grounds are that the tenant has failed to pay rent due and owing provided, however, the rent due and owing or any part thereof did not result from rent increase. And then, or for the purpose of circumventing this article, the court may consider, among other factors, the rate of the increase relative to the tenant's ability to afford said increase. So that's a difficult measure.
Ambiguous.
It's ambiguous. So tenant's income makes that very clear. What the court would consider in this particular case, it's not about the tenant's ability to pay at the beginning, in the general kind of discussion, right?
Is if there's a conflict.
Yeah.
Okay. Thanks for the clarification.
Any other discussion on the amendment? All right, so a show of hands, everyone in favor of amending to say tenant's income as opposed to tenant's ability to pay?
Afforded said.
Say, yeah, ability to afford said increase. Okay, show of hands, all in favor? Okay, thank you.
So those were the only 2 points that I remember that were up in the air
Okay,
in what we presented here. But there are other changes throughout.
right, and those are on the agenda, those were on the document that was published.
But the main one, I think, the reason we sent it back is section 5, subsection A. So changing that from premises with less than 4 units, which is what the amended version that we looked at council, that's what it says. And the proposed alteration amendment here would be owner occupied premises with fewer than 4 total units, including that of the owner. And to clarify, it says that is a property comprised of 1 owner occupied unit and either 1 or 2 rental units.
Okay, and those are the ones that would be excluded.
Yeah, so the idea there is clearly to exclude what we call mom and pop operations. So somebody who's wanting to rent out part of their house, if they've got a couple of units, it would also allow up to a triplex. So if somebody if we alter our zoning code and we've got more triplexes, it would allow for somebody who owns one of those to be excluded in renting out the other 2 units as long as they live in one triplex.
Is there a motion to consider this amendment? Oh,
Well,
this one was already published, so.
yeah, so this is just part of the whole thing.
Okay,
We
so,
can-
yeah, so any discussion on this particular point or any other point of the legislation as was published? Don Tollerman and then Michelle Hirsch.
Okay. So since our last council meeting where this was pushed back to committee, and the press covered it extensively, I received an outpouring, because I was vocal in my opposition to this, I received an outpouring of calls and emails from small mom and pop owners crying for help, the arguments that I presented and Patrick, presented last time, maybe I'll touch on them, but I want to share a couple of thoughts that I'd heard from people, from constituents. And one is that the fact that the majority of our residents of our tenancies are 4 units and below. I think it was 60%. That really speaks to the number of mom and pop small businesses that there are. These owners and it's really a vital stream of income to these owners who are, for the most part, residents of our city. A constituent made the point that these investments that they've made are probably, on average, the largest investment held by mom and pops, and that they are very vulnerable, that if they're one financial crisis away from being in trouble. In other words, we talk about the tenants being vulnerable. The point I'm making is that the mom and pops are very vulnerable, because this is often, if they own one or two of these, if one tenant is, say, a nuisance tenant and they're unable to evict them, or they go to the judge and, after 6 months, the judge decides on, that the tenant, there's no proof that the tenant is smoking, there's no proof that the tenant is using foul language, and so they can stay indefinitely, or if the tenant is just not able to pay according to the judge's determination, then the owner of the building is in crisis, and because they're not able to possibly pay their mortgage, they're not able to pay their expenses. So, we're not talking about the large developers for the most part. Most of our small buildings are owned by small investors. I happen to be one of them. I've made this point before. I own a three-family house on St. James Street, and each of those tenants are great, and I keep the rents below market. I find that many of the mom and pop owners do the same thing. They want tenants that have a good relationship with them, and they're not gouging. And some of the larger prices, yes, it happens, but it's typically not with the mom and pops. And I think that by saying that this needs to be owner occupied, that the owner has to live in the building, really puts most of these apartments, most of the owners, it puts them in a precarious position. So I really vehemently oppose the idea of owner occupied. And I think that we came to a fair, what's the word, when we talked last time in committee, and we came to this this resolution of only 4 units and up to 4 units. I think that was a fair conciliation on both sides. So that's, look to hear your guys' thoughts.
Sure.
Yeah, I just, my concern is just where the number that everyone was speaking of in the public comment, where they're getting that number. So,
Which number?
60%.
Oh, yeah, I don't know.
But it was a great number of them that said it.
Might be true. It might be true.
I don't think anybody said where they got. I'm assuming they got it from the county, but I don't think.
I think the city keeps track of that information.
I'm sure the buildings department would.
Yeah,
have that.
because they have to be registered.
Right. So I don't know if anybody reached out to them.
I understand that some property owners are concerned about this. We've seen this many times before, new legislation. It can be, it's new. People aren't clear what the ramifications might be. But the example that Don just brought up is actually covered right here. The tenant who is causing a nuisance, which includes smoking inside the residential unit, that person under good cause eviction can be evicted from the place where they are. I had somebody call me too, a property owner. She gave me 2 examples and said, no, I'm going to be stuck in this case. I pointed out both examples are covered under the grounds in section 6. So the point here is not to punish good landlords, good housing providers. The point is, as always, we have to look out for those people who are creating a bad situation, who make a bad name for all housing providers. And that's what we're trying to guard against here. That's the crucial thing. And we're also trying to balance the power that the property owners have with the great need to care for those people who make a home somewhere. Because a house is not the same, a home is not the same kind of good or service that we often think of when we talk about the open market. It's something much deeper and fundamental, much more fundamental than that. So when we are talking about providing homes for people, we have to take care too to really think about the people who are in the homes. And we want to balance the relationship. And we're doing that here not through any great, huge change, but really through codifying what's common sense in the first place. And I think, as I've said before, I think this might just as well be called reasonable explanation as opposed to good cause, because it's clarifying for both parties what's involved in their relationship. And it's making it, I think it gives then the people who are renting a greater sense of the possibility of a home that they can have for, a good period of time. You can move out at some point, everybody's going to change at some point, but we just want to make sure that both parties are on the same page, and that's what this allows. And then we want to make sure too that if some kind of disagreement arises, there's a clear mechanism for them to resolve that. There's oftentimes this legislation has actually led to people discussing issues first as opposed to going to a court of law. When I was talking with Judith Goldner, who's a lawyer who's been very deeply involved in this kind of work, her experience has been that it has led property owners and tenants to actually discuss things first. And so it's reduced the necessity for court appearances. It's reduced the necessity for bringing in the long arm of the law to try to resolve these issues. But that mechanism is there, the mechanism of the court is there precisely so that it's clear what method people can move to if all else fails. That's why I'm in favor of this resolution as amended here.
Barbara?
I just want to bring something to the committee's attention. We may need to discuss it in attorney-client session thereafter. But the fact of what I will share with you is a matter of public record, and I want to put that here so that everyone has it. And we can obviously go into more detail thereafter, but just to clarify the point of the codification. This, I think I have enough copies for everyone. This is the copy of a summary complaint that, again, we can discuss in a little bit more detail offline. That addresses or raises certain concerns about the scope of codification. And just so that what I'm talking about, it's a lawsuit filed in Albany Supreme Court. But again, we can go into the detail offline, but it goes, I'm raising it now because it goes to the scope of appropriate codification, at least so far as some claims.
So we can't discuss any of it.
I don't think we can discuss it with reference to what the committee is contemplating unless we go into attorney-client session.
Okay.
But because it's such an important, this is such important legislation, I want to just make it available to you while we're still public. And if we want to go into session, we can continue the discussion.
So is anybody interested in going to attorney-client session to hear an explanation?
I'm not sure, can you, we said scope of codification, I'm not sure what you're talking about.
Sure, and again, I don't want to go into too much detail, but the conversation you were just having was about the codifying, not necessarily new principles, but codifying what is common sense understandings about what is already happening in many cases and should happen. And so this litigation deals with that question as to whether it is codifying something new or reflecting something that already exists in this common sense. But again, we can go into further detail offline.
I think we should, because I really still don't know what you're talking about.
All right, show of hands, anybody, we don't need a motion to go into attorney-client session?
No.
Anybody who's interested?
Yeah, we need to understand.
So, I think we should probably go into,
So we could just use the conference room?
right.
Wake up, Elissa. All right. Right in the middle there.
Okay, welcome back, everyone. We're back in session. Any discussion regarding the good cause eviction legislation?
Yeah, it's, we're good to go. Right, Alyssa, you there?
Here.
All right. And by you, we mean the whole world. So.
Yes, you're all set.
Great.
Alderman Tallman?
Thanks, Jeffrey. I want to respond to Rennie's comments before we broke the session. You know, when he said that for the example of a nuisance situation of a tenant that's a nuisance, someone, for instance, who's smoking, that we have that covered, that they can find satisfaction by the landlord can take it to court and the judge make a decision. So when he says we have that covered, yes, in the words, it's covered, but in reality, number one, going to court costs money. You have to hire an attorney. It takes time, could take many, many months for a resolution. And then for the nuisance, you have to prove that this person is being a nuisance. So let's say someone is smoking cigarettes and bothering the other tenant. How do you prove that they've been doing that? You either have to show pictures or the other tenants have to sign a deposition, or they have to, you know, they have to agree and speak and provide evidence. And tenants won't do that, you know, so because they're afraid that the offending tenant might be angry at them and might hurt them. So I think no tenant will speak badly of another tenant. They'd rather just move. So while Rennie says we're covered, I just don't think that's a very realistic to rely on the mechanism of the court. The other point that Rennie made was that there is a balance. This restores a balance of power. And, you know, I really believe that tenants need protections. I really do, because I think when you're having a hard time and you know, some landlords do take advantage of you, but I believe that that's not that the balance of power, you know, is a funny term, because is it really a power struggle? Is it really the owner should, in my opinion, they've made the investment, they've taken the risk, and they've bought a building, maybe they've improved the building, they're taking a great risk, it's their property. Should the tenant have equal power? You know, I think that the tenant protection should come from the state, not from the owner. Tenants do need help, and they shouldn't be fearful of being put out in the street. But my point is that should be the responsibility of the state or local government, not the responsibility of the housing provider. So I just wanted to respond to those points Rennie made.
Any other comments?
I would like to make a motion that we table this legislation. I believe that there's other forces, there's other conversations on the state level that impact what we do on a local level, and that what we do on a local level might conflict with what the state decides to do. And therefore, I think it's wise to table this for a month or two until the state clarifies this law that's now being discussed in Albany, pursuant to the Albany law.
Okay, we have a motion to table. Is there a second? Okay, the motion doesn't move. There was no second. So any discussion on this? So Lorraine, you made a motion. What was that motion?
The motion was to accept the resolution as amended.
Yes, as amended as per attached, and you will send out to me and Lisa, please.
First motion on the table, motion.
Yes, and you have a second.
A second.
You maintain your second. Okay, so there's a motion by Scott Childress, second by Rita Worthington. Any other comments? Before I go for the vote. All right, all in favor? Opposed? Okay, it passes 4-1. The one opposed was Alderman Don Tolliver. Lisa, I have two committee reports from tonight. I will leave them in the desk at the majority leader's office.
Great, thank you.
That concludes our agenda. Any other comments, discussion, any other issue? All right. Oh, yes.
Thank you for your service, Chair, of all the rules.
Oh, yeah.
Thank you.
This was your last.
I forgot, this is my last
Your
meeting.
last one.
Where's the cake?
I thought you were bringing that.
Me? I'd bring sweet potatoes.
So, wait, so then your last final thing would be the CDBG, right? Meeting?
That's canceled.
Is that canceled? So this
Public
is it?
safety.
Public safety and that's it? Wow.
And the special council meeting on the 29th.
That's right. Yeah, wait, the 29th or 23rd?
The 29th.
Oh, the
okay.
December 29th. That's right. So the last time, as Greg said, I don't know if I should say congratulations. or-
Thank you.
Sorry, I interrupted you.
Yes, so is there a motion to adjourn?
Motion.
Motion, second by Rita, all in favor? Okay, we are adjourned.
All right.